This is part 2 of a cross-examination that may only happen once in a lawyer's lifetime. Our claim was that the hospital should have brought in a specialist while our client was in the hospital. I crossed the defense expert with the rules contained in his own book. The defense expert tried to wiggle out and testify that the first ultrasound was severely technically limited, and that's not what he meant by poor quality and indeterminate as he wrote in his book. But this sentence was not the only ammunition I had in his book. You see, earlier in the trial when the defense expert wasn't there, I got the defendant nurse practitioner to agree that the history and physical findings of our client was suggestive of the disease. And now it was time to cross-examine the expert on the most damning statement in his book. In the book, he wrote that due to the importance that time plays in the treatment of the condition, patients with historical and physical exam findings suggestive of the disease should have emergent urologic evaluation. Then when the expert tried to claim that the history and physical wasn't suggestive of the disease, I was able to show him and the jury the testimony from the defendant from earlier in the trial where she said it was. Then it was time to cross-examine him on the very long-standing, lucrative relationship he had with the defense attorney.